The broadcast is now starting. All attendees are in listen-only mode.
Hi, everybody. Good afternoon, and welcome to our webinar on representing survivors in removal, identifying and presenting applications for relief. My name is Amy Cheung. I am a senior legal counsel at Assista, and I'm joined today by Gail Pendleton, our executive director. In today's webinar, we are going to be covering some material from our in-person trainings at the FBA and AILA conferences that happened a few weeks ago. We're going to be focusing today on identifying presenting applications for relief. This is part one of a two-part series. The next part, which will cover procedural issues in removal proceedings, will take place in July. If you are barred in Texas and would like CLE credit, hopefully you submitted your Texas CLE bar information when you registered. If so, we'll submit that information to the bar authorities automatically. You shouldn't have to do anything else. If you are licensed in another jurisdiction and would like a certificate of attendance, please email us with your name and bar information, the state where you're licensed, so that we can send you your certificate of attendance. Okay. And with that, let's move on to the next slide.
This is being recorded, right, Amy?
Yes, I think all of our webinars are recorded. So we'll be sending out a follow-up email in the next few days with the recording from the webinar so that you have all of that information for future reference. And it'll also go up on our private member YouTube page as well, I believe. Okay. And then our goals for today's webinar are that by participating, participants will be better able to identify forms of relief for survivors in removal proceedings, prepare evidence to prove eligibility for relief, and then present the merits of an application for relief. Next slide. So we're going to get started with a little polling as usual. And so the first question is, in the last year, you have represented a survivor in removal proceedings. So
and for those, have we discussed the questions Dropbox yet? No, well, people are waiting for things to.
Oh, sure. For anybody who hasn't used this format or this platform before, in your control panel, there should be a spot where you can ask us questions. It's labeled questions. And so you can send questions to Gail and me during the presentation, and we can respond to you. Depending on the question, what the question is, we might respond out loud to the whole group, or we might respond directly to you. You can also let us know if you have any technical difficulties during the webinar as well. Okay, so I'm going to go ahead and close this poll. And we have here 53% of you guys have represented somebody in proceedings in the last year, or a survivor in proceedings in the last year, and 47% have not. And so this is pretty typical. We see a lot of members and other practitioners who routinely represent survivors in proceedings, and some who don't do so quite as often, but of course, you might be representing non-survivors in proceedings and might be very experienced in that context. So that's helpful to know. Thank you. And next up, please. Oh, hold on. Okay. All right. So next up, we will be discussing some issues around requesting relief in immigration court. Next slide.
The poll's up. Are we going to do the poll?
Yes.
Okay.
Okay. So let me pull up the poll. So a little more polling to see who we have in the audience today. So for those of you who practice in immigration court, regardless of whether you're representing survivors or not in proceedings, in immigration court, if I do not believe that the client or prospective client is eligible for relief, and you can select all that apply. And your options are: do not accept the case, argue that the client is not removable or that the court doesn't have jurisdiction or make some other kind of procedural argument to challenge removability. File for asylum or withholding as long as the client expresses a fear of return or other.
Amy, clarifying question. When you say eligible for relief, you mean survivor-based relief? Because you're kind of assuming there might be an asylum option, right?
Yeah, I mean, I think it's any kind of relief. I think this question is really more about approaches to removal proceedings. Obviously, for today, we're going to be focusing on remedies for survivors because that's what we do at ASISTA. But of course, there are other remedies available to respondents in removal proceedings that are not necessarily survivor-based. And so, obviously, if a survivor is eligible for another form of relief, we would
help you pursue it.
Apply, not just the survivor-based ones.
Yeah. Okay.
So, all right, let's close this poll and share the results. Okay, so we've got 47% say do not accept the case, 50% say argue that the client is not removable or that the court lacks jurisdiction. 40% say file for asylum or withholding as long as the client expresses fear, and 23% say other. If you said other and you'd like to share your approach in the questions box, then we can share those with the group as well to share our experiences. With respect to arguing that a client is not removable or that the court doesn't have jurisdiction, we're going to be talking in much more detail about procedural challenges and substantive challenges as well to removability in our July webinar. It includes all kinds of things, including challenging the NTA, disputing or denying the allegations on the NTA, and other things of that sort. And so there are all kinds of challenges to removability that are worth considering, but we're not going to have time to discuss those in a lot of detail today.
But we are really glad that many of you are challenging removability, and on the next webinar, you'll also hear some survivor-based arguments you can make.
Absolutely. I think there is a tendency, and there has been a tendency for a long time for people to just automatically admit allegations. There are times when it is appropriate to admit allegations, but there are also certainly times when it's worth considering how to challenge them. And then as for filing for asylum and withholding, it's tricky, right? Because there are a lot of clients who do have a fear, but for the attorney, it's a question of whether or not you can come up with a legal argument as to why your client is actually eligible for asylum or withholding, which can be quite complicated. So we encourage you, to the extent that you're trying to come up with arguments for asylum or withholding, that you consult with organizations like the Center for Gender and Refugee Studies out of UC Hastings and other organizations that really specialize in asylum-based arguments. Okay, so I'm not seeing any other options here, so I think we can move on to our next slide. Okay, great, one more poll here. So in immigration court at the master calendar hearing, sorry, let me find results. There we go. In immigration court at the master calendar hearing, I provide evidence of eligibility for relief. So this is eligibility for relief, not just the application that you might need to file at the master.
So you mean like you would file the 360 or the 918 or whatever, or you'd show it to them?
Yeah,
Okay.
to the judge and potentially even make some arguments and evidentiary showings at the master calendar hearing, as opposed to just filing the documents.
Right.
All right, let's close this poll and take a look at the results. Okay, so 58% say yes, 33% no, and then 8% I have never appeared in immigration court. Okay. So the reason why we ask this question is because we've noticed some variation in terms of local practices about what individual immigration judges might require from attorneys at master calendar hearings. And what we've been hearing is that while there are some judges who will accept the forms, the application for relief, and then just go ahead and set it for an individual hearing, there are other judges who will require a lot more evidence at even just the master calendar hearing before they'll set it for an individual. So we'll be talking about that in more detail on the next slide, but if you're not very frequently practicing in immigration court, if you're in front of a newer immigration judge or a judge that you've never appeared in front of before, it can be really handy to talk with other local practitioners who do a lot of removal proceedings to see what the preferences are for the judge that you're going to be appearing in front of, so that you're not unpleasantly surprised when you show up at the master calendar. Okay, next slide, please. All right. So we're done for polling for the time being. At your master calendar hearing. So for purposes of today's presentation, as I said earlier, we are assuming that your client has been found removable because we're going to be saving those procedural issues and procedural challenges to removability in the next webinar. So the IJ has found that your client is removable from the United States. Now, what are you going to do at the master calendar? You'll need to ask for relief. You'll need to state what claims your client has for relief, and then eventually you would need to submit those applications to the immigration judge and then ask for your merits hearing. All right. So one of the things that we wanted to talk about was this issue of when your judge is asking for eligibility, proof of eligibility at the master calendar hearing, what are some special concerns when you're representing a survivor? And one of the things to keep in mind is that if your judge is going to ask you to articulate eligibility for relief, then you're probably going to have to do it, right? You're probably not going to be able to avoid making that offer of proof. But at the same time, you need to keep the safety and confidentiality of your client in mind.
Yeah. So Amy, can I just clarify? Offer of proof isn't really the same as like submitting a filled out 918, right? It's more like bullet points of what you will submit down the line.
It depends on the judge. I mean, there are some judges who will ask for full briefing at a master calendar hearing. There are judges who will ask for a full affidavit from your client before setting an individual hearing. It really depends on the judge.
Okay, and then Tess was asking, let's assume for the moment that you are, well, what about, for instance, if like you've got a U or a T and there really isn't anything a judge could do, could you just show the receipt that Vermont got the application, or do you need to supply the whole application plus the receipt? And excuse me if I'm jumping the gun.
I think it depends what you're asking the judge to do, right? So we are going to be talking in more detail about what to do when you have a pending U visa application later on in this presentation, and we're going to be covering it in more detail, especially with respect to asking for continuances based on pending U visas in the July webinar. It depends on your judge. It really depends on the judge, I would say, is the primary issue. Because there are some judges who will be completely fine with just the receipt notices. They could get you on the status docket or give you a lengthy continuance just based on offering your 918 receipt. There are other judges who won't do that.
Yeah, and so for instance, let's stick to the VAWA stuff since that's what we're going to get into here. So let's assume that you have filed a self-petition. It hasn't been acted on first, but that might open up both a request for an adjustment and or cancellation, right? So I guess I would rather not submit the whole self-petition. I would rather just submit the sheet showing that Vermont got it and say, we'll get into the arguments when we have the merits hearing. But you're saying some judges won't even accept that?
I think there's some that it won't. I've seen some that won't.
Okay.
Yeah. I think the argument, if all you have is a pending self-petition with USCIS, is that the case is properly before USCIS and that the judge isn't deciding anything on the self-petition at the moment. But if you are concurrently applying for VAWA cancellation, then that is properly before the judge. And I think it's more likely that the judge might require evidence as to cancellation eligibility.
Cancellation, right. So you could probably argue, I'm sorry to belabor this, but I'm not sure you're going to cover this later. You probably could argue that the self-petition itself actually isn't relevant to the judge anyway, because they can't do anything about it, that it may down the line be useful evidence for the VAWA cancellation, but rather what you would do is file the 485. I guess you can't file a 485, but you'd say you're requesting adjustment based on that plus VAWA cancellation. And then you might have to file the VAWA cancellation form, it sounds like.
Potentially, yes. I mean,
Okay.
typically at a master, you would be required to state all the claims of relief for which you're going to be applying. So if your client is both VAWA adjustment eligible and cancellation eligible, then you might need to file both claims for relief at the same time.
Okay.
And yeah, so it depends. It depends.
Okay, so I was curious about your practice pointer on the manner of entry and date of entry, because presumably if you've conceded removability, you've done a little bit of that already. So what are the nuances?
Yeah, I mean, if you've conceded, well, you can concede removability while also making any corrections that are necessary as to the facts in the allegations, right? So if they're alleging that your client EOIR, they'll typically put that your client entered without inspection, through a particular port on or about a particular date. To the extent that that's relevant to your case. So for example, let's say in a VAWA cancellation case, you're trying to prove continuous physical presence for 3 years. If you're close to that 3 years, if your client arrived, relatively recently and you're a little concerned about showing that continuous physical presence, you want to make sure that that date of entry is accurate. So there, and also just generally, even if the manner and date of entry aren't particularly important to what you're asking for, you want to make sure that whatever you're conceding to in the removal proceedings is actually accurate.
Well, plus down the line, that stuff will have some effect on your unlawful presence arguments for adjustment if you're doing that.
Certainly, yeah.
Yeah. Okay.
Yeah, so they can come up in all different kinds of contexts. It's not just some, throwaway thing that you would just concede in the allegation. So even the small things like that, you want to check before you concede them.
Good.
Okay, and then going back to the confidentiality issue for a moment, to the extent that you have a judge who wants to talk about any detail regarding your client's eligibility for survivor-based relief, it's really important to keep in mind that master calendars are open hearings. You got typically tons of people in the courtroom. You don't know who else is there. Your client doesn't know who else is there. The abuser could even be there, or people who know the abuser could even be there. And so to the extent that your judge is asking you to discuss or disclose anything related to the merits of the application, it's, I think, important to talk with the court clerk about this before the hearing, if you know that the judge is likely to do this, or if it comes up and you haven't had a chance to talk to the court clerk, to put it on the record that you, for confidentiality purposes, you need the courtroom to be cleared for the safety of your client.
Well, and even prior to that, I mean, it used to be a rule. I mean, I'm surprised if this rule has disappeared, and we need to revise it if it has, that if you identified a self-petition or cancellation case this was before use, going before the court, that they would actually take the A number and name out of the file so that abusers wouldn't get notice that they were showing up at court, because they don't want abusers showing up at court even for a master calendar hearing. So maybe if you are worried about that, it really may be worth talking to the court ahead of time, the clerk, to see if they still have that option.
That's a great tip. Yeah, I would definitely encourage people to do that. Okay, and next slide, please. Okay, all right. So as I mentioned earlier, we're going to cover the procedural issues around continuances for pending U visas in much more detail in July. For today, we're just going to be talking just briefly about some strategies. So obviously, a lot of you guys have clients with a pending U visa petition and potentially no other strong form of relief in immigration court. Depending on where you are, you may have more or less luck with some of these strategies. So starting off with requesting termination, depending where you are, DHS might not oppose. I think that there are some jurisdictions where that is much less likely than in others. You guys know your jurisdictions better than we do, your local TAs. But at the end of the day, you have nothing to lose in requesting termination. Your client has nothing to lose by requesting this. So why not try it? There's a chance that DHS won't oppose. There are lots of times that they never even respond to a motion, no matter what it is. And if you get really lucky, maybe if you have a particularly compelling case or a particularly helpful TA, DHS could potentially even join, although these days I think that's fairly unlikely in most places. And then if they do join, then you've got DHS on the, and you potentially get DHS to stipulate eligibility for a U visa, which will be extremely helpful for you when it comes to USCIS's adjudication of the U visa claim. So it's something to consider.
I also think think about using these initial hearings as a way to kind of gently and not stridently educate your IJs and OCCs about the history and purpose of this law. You know, that there are all these special protections that you're articulating. Maybe they aren't going to agree with you that they should terminate, but then by the time you get to the meat of the argument, they'll have heard this 4 times, that, you know, this is a special thing and there's special rules and they shouldn't be trying to deport these people, basically.
Yeah. So it's always worth educating the IJs and OCC about this. As we said, this is one of those things where it doesn't hurt to try, so you might as well. And if you get it, how amazing would that be for you and your client? The slightly more likely option, I think, for most people is getting a continuance. So obviously requesting continuances, Sanchez-Sosa, matter of Sanchez-Sosa is still good law. We still encourage people to use it, and we'll be talking about that in more detail at the next training. But if you have questions in the meantime, please shoot us an email or send a TA request. Also, there are a number of courts around the country that have status dockets where they'll essentially put the case on a hold while USCIS is adjudicating the U visa application, and then you'll just need to check back in with the court, depending on what the judge tells you to do, to provide status updates and status checks as the U visa case progresses.
So in Austin at the training, people said that I think it was San Antonio, where they've been able to convince IJs to put things on a quote unquote status docket, even though they don't have a status docket. So is that what like a status check is? That even if they don't have an actual status docket, you can ask them to do a equivalent to that?
Yeah, I mean, I think it's functionally very similar to a continuance also.
Right.
So in terms of procedure, I don't see a huge difference between asking the judge to reset it for a status check and asking for a continuance. Perhaps in the minds of some IJs, there is some kind of difference there. But to the extent that you think your judge would be amenable to it, or even if you're not sure, you can try it and just see what happens. I mean, if your client is in proceedings anyway, you just don't have that much to lose. So you might as well ask for whatever you can.
Yeah, and maybe after the 50th person has to put on a status docket, they'll decide they need a status docket.
Right, right. And it's also something, you know, to the extent that in your area, you guys have some kind of liaison relationship with the court or anything like that, that it's worth using that relationship to push for status dockets and things like that.
Definitely.
Some of you may have clients who already have an order of removal from the court, but where the cases are up on appeal to the BIA. If that's the case and your client has since filed a U visa petition, then file a request to remand. These are working, and if you need help with your motion, you can let us know. We're happy to walk you through the process. But as I said earlier, Sanchez-Sosa is still good law, and it's still useful in making arguments for remand if your case is up on appeal. And also, generally speaking, the BIA kind of likes remands as opposed to deciding merits of appeals. So it makes them feel, it helps them avoid issues, which is something we oftentimes like to do.
Yeah.
Okay, and then another option, which we will be discussing today, is requesting a D3A waiver. So for anybody who's not already familiar with this, this is an alternative non-immigrant waiver. That's in addition to the D14 waiver that we have for U visas. And this is a general non-immigrant waiver. It is a little bit more restrictive than the D14. But the nice thing about it is that the immigration judge has jurisdiction in the 7th and 11th circuits over the D3A waiver. If you're in another circuit and you're interested in pushing this argument, please reach out to us. We'd like to talk with you about this.
Yeah, we work with, I just want to give kudos to the National Immigrant Justice Center, which are really the people spearheading this. We're just working with them to make sure we're all on top of this and everyone's making the arguments and working together.
Absolutely. And NHIC also has a great practice advisory on these D3A waivers, especially in the 7th Circuit where they're located. And the thing to keep in mind when you have a case with a pending U visa petition is that your ultimate goal, unless your client is also eligible for relief in immigration court, is to keep the proceedings open, to keep the case alive, avoid the final order of removal, because there's actually a risk to your client that he or she will be removed. And we've been seeing these more and more often. I wouldn't say it's a ton of cases, but there's definitely been a handful over the last couple of months where ICE has actually been trying to remove people with a pending U visa application who had a final order of removal. So this is a real risk for clients right now. And so to the extent that you can avoid a final order of removal, do so. Next slide, please. Okay. For a pending T visa, it's really quite similar to a U visa in that you can file a motion to terminate, you can file for a continuance, you can file for status dockets if your court has that. The thing that is more likely to be available for T visa petitioners versus U visa petitioners is admin closure, because there is a regulatory provision that specifically allows for admin closure in the T visa context. So if you have a pending T visa application and for some reason you can't get termination, then it's worth pushing for admin closure over continuances and status dockets. And then because T visa petitioners will lose eligibility for the T visa if they're removed, then it's even more important to keep the case alive and avoid final orders because T petitioners with final orders are also at risk for removal, just like U visa petitioners are. Okay, next slide, please. Okay, so next up we have a poll. And so we're just looking for some information sharing about local practices on people with final U visa grants. So we're not just talking about people on the U visa waitlist, we're talking about people with a final U visa grant. So if your client has been granted U non-immigrant status, but is also in proceedings, your local OCC will select all that apply.
Mostly they don't respond, it appears, so far.
Yeah, which is not surprising. Pretty powerful for OCC, but I'll just give it another minute so that everybody who would like to respond can. All right, I'm going to close this poll and share. All right, so as Gail said, the vast majority of you guys are reporting that your local OCC will not respond or do anything if your client has been granted non-immigrant status. There are a lot of OCCs who will oppose your motion to terminate, which is what we've been hearing as well. Some of you report having OCCs that will actually join your motion to terminate, and a couple have OCCs that will even move to dismiss the NTA, which is great. That is what they should be doing. And then a couple of you are reporting that the OCC will reissue the NTA and recharge under 237A. If that's what you're finding, please let us know. That's something that we're interested in looking into. Obviously, if your client is actually deportable under 237A, that's something that OCC can do, but it's obviously completely contrary to the goals and purpose of the U visa program. So that's something that we would definitely want to know about and to look into.
Because one of the arguments, right, is that the board in its unpublished decision has found that a U grant is an admission, right? So that means they have to charge you under the grounds of deportation, not inadmissibility. That's
right.
Why.
I mean, I think most U visa petitioners and proceedings are being charged under 212A, and
Right.
oftentimes they're being charged for being present without admission or parole, right, under A6AI.
And now they're admitted.
And so the problem for OCC, the good thing for us, is that the board seems to be on board that a U non-immigrant status grant is an admission to the United States. Your client is in lawful status, right? And so the admission overcomes removability under A6AI. There's an unpublished case that's in the materials in the Dropbox for you guys to look at that offers some good language to use in your motions when you're moving to terminate. And so we encourage everybody to be filing motions to terminate. To the extent that you can get OCC agreement on these, that's great. But file the motions. It doesn't matter if OCC opposes, right? If removability has been overcome through the grant of the U visa, then it's been overcome and your client should not be in proceedings.
It would also be good to get the board to actually agree with its unpublished decision. We did a brief with AILA. They had sent out a request for amicus briefs on the question of whether a U grant was an admission, and they seemed to agree with our arguments, but they didn't publish the decision. So it'd be nice to see the board actually implementing that.
It would be. I will say that their unpublished cases are relatively consistent with regards to this. So it's something that works, but obviously published cases would be better than published.
Okay.
The other thing to keep in mind is if you have an OCC that has a practice of recharging under 237A, and also just as a general rule, make sure that all the applicable grounds of inadmissibility are actually waived on the I-192 when you're filing the U visa. If you're missing grounds of inadmissibility, then that gives OCC a much better argument for recharging under 237A for being inadmissible at the time of admission. So, and obviously just generally for your practice, you should always make sure that the grounds are being waived. Okay.
Oh, so the unpublished, they're asking where it's on our website. Both the unpublished decision and our amicus brief to the board should be on our website. I would start by looking in the U section.
The latest unpublished decision is also in the Dropbox.
It is. Okay, great. There you go, Ashley. I think it was it last year or 2 years ago? I can't remember how long ago it was there.
The first one was, I think, at least 2 years ago. The most recent one is from June, from this month. Yeah.
And there was another question. I just want to make sure I get the right answer. You are going to get into the D3 waiver stuff later on, right?
Yes.
Okay. Thank you.
Okay. So we've talked about OCC. Let's talk about IJs. So next poll, if my client has been granted U non-immigrant status, but is also in proceedings, my local immigration judges will select all that apply. And your options are terminate or dismiss proceedings, put the case on the status docket or continue proceedings, order removal if no other relief is presented, other, and depends on the IJ.
And someone asked a good question, which is for those of you who are seeing OCC recharge under 237, what grounds? So I'm going to send a note out on the chat to everyone and you can reply to me. So look at your chat if you have that.
Okay, so I'm going to go ahead and close this poll. All right, so that is great. So 8% of you say that the IJ will terminate or dismiss proceedings. It should be higher than that. The percentage of this should be 100%, but it is great that at least 48% of you are reporting seeing that with your local immigration judges. And then 26% say that the judge will put the case on the status docket or continue proceedings. Where we've seen this, it's typically been putting the case on the status docket or continuing proceedings until your client becomes adjustment eligible, or because adjustment is under the jurisdiction of USCIS, the IJ will never have jurisdiction over the adjustment. They'll typically continue proceedings until the client has actually adjusted. We would argue that this is incorrect. There is no removability to be determined here, and so the judge doesn't really have anything to do with the proceedings and should terminate them. But it's at least better than ordering removal, which at least one or a couple of you are reporting that your judges will order removal if no other relief is presented. We strongly encourage you to appeal those orders of removal if no other relief is presented. And if you need help with that, please let us know. We're happy to help you with that. And depends on the IJ. That's also pretty common. Every IJ is going to have their own practices and their own understanding of what it means to be granted non-immigrant status. But again, our position is that proceedings should be terminated once the final grant has been issued by USCIS.
So I said on another chat on that, those of you in that category, if we haven't talked about one of the rationales, the judges aren't doing it, send it to us so we know about it and can share it.
Yeah. And one tip that we've heard from practitioners is that with some judges, even if they don't buy the argument that A6AI or removability has been overcome by the grant, there are some IJs who might be more amenable to terminating if you're able to provide the equities, the extent of the victimization, and some compelling factors behind the U visa. Again, I don't think this should be necessary, and also technically wouldn't be grounds for termination anyway on the part of the IJ. But if you have an IJ who will terminate, if you provide that evidence, then you might as well do it for the good of your client. So. Okay. Next slide, please. Okay. All right, so we're going to move on to identifying relief. And obviously, we're going to be focusing on survivor-based relief that falls under the jurisdiction of the immigration courts. Okay. So the first thing to determine when you're figuring out which relief to apply for is if the judge has jurisdiction at all. And so I'm sure a lot of you guys are familiar with this anyway, but just as a way of a reminder, IJs do not have jurisdiction over T or U non-immigrant status, that's a 918 and 914, or T and U adjustment of status. They also don't have jurisdiction over the VAWA self-petition. That's why we would argue that if your IJ is demanding that you show them the self-petition, that you could argue that there's no reason to do that because the IJ doesn't have jurisdiction. As Gail will talk about later, there are some reasons why you would want to provide that evidence, but certainly sometimes when you wouldn't as well. IJs also don't have jurisdiction over initial I-751s or petitions for removal of conditions. Where they do have jurisdiction is over 212D3 non-immigrant waivers, at least in the 7th and 11th circuits, which we will be talking about today. 245A adjustment of status, which includes VAWA-based adjustment of status. They also have de novo review over denials of I-751s by USCIS. And of course, they have original jurisdiction over VAWA cancellation of removal. Okay. Next slide, please. All right, so let's get into 212D3 non-immigrant waivers. As I mentioned earlier, this is an alternative waiver for non-immigrant status. So for our purposes, we're really talking about U and T non-immigrant status. Obviously for U's, the regular waiver is going to be under 212D14. For T's, it's going to be under 212D13. The standards are different. So a 212D3 non-immigrant waiver, it first of all is more restrictive than a D14 or D13. It will not waive inadmissibility under 212A3C, certain sections of A3A and A3E. Whereas the D14 will waive everything except D3E. So you're a little bit more limited there, but also I would say that the exceptions for D3 are not super common when it comes to you petitioners, so hopefully it wouldn't be an issue in your case. And then the other thing to keep in mind is that for D14, the standard for waiver eligibility is that it has to be in the national or public interest, whereas for D3, you are looking at a three-part test. This comes from Matter of Franca, a BIA case. And so you're looking at the client's risk of harm to society, the seriousness of your client's immigration and or criminal violations, and the nature of your client's reasons for wishing to remain in the United States. And it's important to note out from Matter of Franca that your client's reasons for wishing to remain in the US don't have to be particularly compelling. You don't need to find close family members who require serious medical treatment. It doesn't have to be really extreme. But it's a balancing test between these three factors. And this waiver at the moment is only available in the 7th and 11th circuits in terms of falling under IJ jurisdiction. In other courts and other circuits, the IJs will probably say that they don't have jurisdiction, and this is coming out of a BIA case called Matter of Con. We've included all of the current cases on the D3 waiver in the Dropbox. There's Matter of Con, which is the BIA case. There are 2 7th Circuit cases and 1 11th Circuit case. And so those are all of the ones that are available right now. So if you're in any circuit other than the 11th or 7th and you're interested in pushing this argument, please let us know, let NIJC know, so that we can help you coordinate arguments. And the other thing to keep in mind is that because the IJ would only have jurisdiction over the non-immigrant waiver, you still have to go back to USCIS for the adjudication of the 918 or 914. The IJ doesn't have jurisdiction over those forms. Next slide, please. And just some very basic information about how to file it. So it's the form I-192. It's the same form that you would file with the immigration judge. You are still able to get a fee waiver if your client is eligible. It's recommended that because you do have to go back to USCIS for the ultimate adjudication of the U or the T, that you get everything in writing as much as possible from the IJ so that there aren't questions later on from USCIS as to whether or not the 192 was properly filed, or anything like that, or what the IJ ordered. On the I-192, as always, but especially important here, you want to specify all the grounds of inadmissibility. So USCIS isn't questioning later on whether or not the judge has actually waived all the grounds that apply. If you can get OCC to state on the record that there are no other grounds that apply, that can also be very helpful, because obviously OCC is part of DHS along with USCIS. And then the other thing that is good to keep in mind is that you can file this D3A waiver with the judge before a 918 is filed or while it's pending. There's no requirement that it be filed concurrently or anything like that. So if you have a judge who is requiring you to file for relief in immigration court, and you have to file something over which the judge has jurisdiction, and you don't have anything else that your client is eligible for, then it's worth considering whether you can do a D3A waiver, even if you're still in the process of getting your cert.
Cool. And then you can supplement with your Sanchez Sosa argument later on.
Yeah. And also, the other really nice thing about these D3A waivers is that it makes USCIS's job easier and faster because they don't have to adjudicate the waiver anymore. Yeah. There's no reason for USCIS to be looking at a D14 or a D3 waiver if the judge has already adjudicated it. In practice, I think there's some,
they're not
procedural complications with USCIS and the D3 waiver that make it a little bit more complex than that. But in theory, it could make things more efficient for USCIS.
So I think Clarissa's asking a clarifying question. The D3A waiver, you're just talking about doing it for U's and T's in front of IJs, not for like VAWAs or anything else, right?
Yeah, because VAWAs this is a non-immigrant waiver. Yeah. So VAWAs wouldn't be, if you're applying for a VAWA adjustment, they wouldn't even be eligible. This is only for non-immigrants.
We don't have the expertise to speak to other non-immigrant waivers, but seems like an interesting idea.
Yeah, sure. Okay, next slide, please. All right, next up is something that's probably more familiar to a lot of you guys, VAWA adjustments of status. So generally speaking, a lot of you guys are probably applying for VAWA adjustments before USCIS. But it's important to know that the IJ could also have jurisdiction. It just depends on the posture of the case. So if the client is in removal proceedings, the IJ has jurisdiction. USCIS will not be able to adjudicate a VAWA adjustment of status unless removal proceedings have been terminated. This also goes for if your client's proceedings were administratively closed, back when courts were still doing this quite frequently. USCIS will say that they don't have jurisdiction. And so you would either have to recalendar and adjust in court, or you can recalendar and see if you can get a termination so that your client can adjust before USCIS. And there's no number limit on adjustment grants per year for VAWAs. It is important to keep in mind that the priority date for your client must be current if your client is in the family preference categories. Obviously, if your client is an immediate relative, then there's no priority date to be worried about.
And two practice pointers on that, just for those of you who haven't had a review of VAWA self-petitioning, is you can transfer a priority date that was filed under an I-130 for your client to the 360. And if you have reason to believe that the abusers has adjusted, you might be able to convince them that they're immediate relatives. Am I correct on that?
It's naturalized. You mean
naturalized, that's what I mean, yes. Yeah.
Yeah. Yep. And then also, as always, inadmissibility under 212A is going to apply whether you're adjusting before USCIS or the immigration judge.
But that's not a problem because there's the VAWA exception. So
hopefully it's not a problem if your client meets the exceptions or is eligible for a waiver. All right, next slide, please. All right, so back one. Yeah, there we go. So just very briefly on VAWA and inadmissibility, if you want a more thorough review of inadmissibility, we have a number of presentations that are recorded and up on our YouTube page that talk about inadmissibility and waivers and VAWA in much, much more detail. But as a very brief overview, if your client is adjusting through VAWA in court, the immigration judge would also have jurisdiction over the waivers. And so to keep in mind the exceptions and waivers for VAWA, so there's a special exception to removability for VAWAs if the client's presence in the United States without admission or parole is connected to the battery or extreme cruelty by the abuser. There's also a blanket exception from public charge. So VAWA self-petitioners are never subject to public charge. And there's also an exception to the accrual of unlawful presence if the departure or the violation of non-immigrant status or the unlawful entry is connected to the abuse. And then there are also special waivers, and the difference between an exception and
yes, that's what I wanted you to explain. Thank you.
Yeah. The difference between an exception and a waiver, which is actually extremely important, is that if the exception applies, then your client isn't inadmissible at all. You're not asking for a waiver here, right? Waivers are more difficult to get. They're discretionary. There are factors. With the VAWA exceptions, if you can show that the exception applies, then that ground of inadmissibility is inapplicable to your client. It doesn't matter if your client, the fact that your client EWE'd would be irrelevant to their eligibility for adjustment, for example.
And this is one of those removability arguments we'll get into next time, which I don't think any of you are arguing yet, but if you can show that your client meets the 212A6A exception, you can argue that that ground that they've charged you with doesn't apply, so there's no jurisdiction.
Yes.
So go forth and prosper.
That will be discussed in more detail in July, so stay tuned for that. And then there are other grounds of inadmissibility for which the ground does apply, but for which there is a special waiver for VAWA self-petitioners. So if your client is inadmissible for having a communicable disease, you look at 212G. For criminal grounds, you're looking at 212H, fraud, misrep, 212I. And then if your client is subject to what people often refer to as the permanent bar, then there is a special VAWA waiver if the departure or the reentry that triggered the bar is connected to the abuse.
And can we just remember a little bit the content of these? Because as I recall, especially the H and the I are really excellent waivers. Like I think H for crimes is essentially you are a self-petitioner, period. And then,
I think that's correct. And I think 212G is the same.
right.
212I, you do need to show extreme hardship to a qualifying relative or yourself.
Right. That's so I was involved in the EOIR fixes for this. So basically what we got in a lot of them, including this, is the old language glommed onto the new language that applies to everybody else. So it used to be you could show extreme hardship to yourself. That's now gone for everybody else, but it's still there for VAWAs.
One thing that Gail and I were talking about before the webinar today is with regards to clients who could be subject to reinstatement. So
Yes.
if you're applying for adjustment through VAWA before USCIS, then the protocol is that you file the 485 with the I-601 to waive the 212A9C plus an I-212 for your advance permission to reapply for admission. Which would cure the reinstatement problem. If you're in removal proceedings, then DHS has necessarily decided, at least for the time being, not to reinstate, right? Because if they had reinstated, then you wouldn't be in removal proceedings at all.
Yeah.
So the procedure of this is a little bit different. But if your client is subject to A9C, then you would still be able to apply for that waiver in immigration court. And the question would be if your client was previously ordered removed, because obviously A9C can be triggered if you accrued a year or more of unlawful, or over a year of unlawful presence and then left and then EWI'd back in. But it can also be triggered if you were ordered removed, left, and then came back in. And so if you were ordered removed, then you would have also triggered 212A9A. There are time limits on A9A, so if those time limits have not expired, then your client would be inadmissible under that ground as well. And there's no specific waiver for it. Instead, your client would have to request a nunc-pro-tunc advance permission to reapply for admission. And then you can take a look. There are some BIA cases on this. There's one that's matter of Garcia Linares. That one is not in your Dropbox, but it's not a VAWA specific case, but just generally speaking, these nunc-pro-tunc advance permission to reapply for admissions can be available in immigration court for people in this position.
So once again, we're flagging for you that if you think your client has a VAWA reinstatement, which is very likely if they have a 212A9C problem, let us know sooner rather than later, because I think we figured out the system for the administrative fixes for it, but we're still not sure how it's going to work in proceedings. Like how much do you have to do ahead of time and how much could you do in front of the judge? So we'd love to work with you on that.
All right, next slide. And then whenever you're looking at waivers as opposed to exceptions, it's important to keep in mind that these waivers are discretionary. So in addition to showing that your client is statutorily eligible for the waiver, so for example, you would need to show that your client is a VAWA self-petitioner. For the fraud and misrep waiver, you would need to show that your client would suffer extreme hardship or that a qualifying relative would suffer extreme hardship. So in addition to that, you also need to show that your client warrants a favorable exercise of discretion. And that's a balancing test. And so you want to make sure that you're showing your client's positive equities and you're making an argument that those positive equities outweigh the negative facts, the negative factors in your case, right? And to the extent that your client has immigration and criminal violations. It's important to take responsibility for those, express remorse, and show rehabilitation. Those are the really key things when you're talking about positive equities here. I think for future slides, we will switch the sides on this scale of justice so that the positive equities outweigh the negative facts, because we're going to think positively about this. But it is a balancing test. So make sure that you're making the showing for your client when you're asking for the waiver. Okay, next, please. Okay, so another poll for you guys. Let me pull this up. So, have you ever adjusted a client before an immigration judge? Okay, so almost everybody's responded, so I'm going to go ahead and close. And so it is almost half and half. So a little under half of you say yes, a little over half of you say no. And I would guess that for many of you guys, the reason that you haven't adjusted a client before an IJ is oftentimes because your client was not in proceedings. And so your client was able to adjust before USCIS. If your client was in proceedings, historically, it's often been possible to terminate proceedings. But let's talk about this a little bit more. Next slide, please. So for those of you who answered yes to that poll, yes, you have adjusted a client before an immigration judge. What differences, if any, did you note between the in-court adjustment of status and the adjustments before USCIS? And this could be anything. I mean, think broadly, but specifically, if there were differences in how the adjudicator or the officer or the judge were considering issues of discretion, or how they were analyzing issues around inadmissibility. If you could just share your experiences with us so that we can talk about them. Okay, so Tess is saying that in proceedings, adjustment of status is much easier. So could you explain a little bit more about that? What have you found to be easier about adjusting before the immigration judge? And 47% of you are saying that you've done this before. So hopefully you'll be willing to share some of your experiences with the group today so that we can all learn from each other.
I mean, my experience when people used to do a lot of this is that I think IJs, just these cases seem so much more sympathetic to them than a lot of other cases they get. Whereas I think the problem that we've seen with the Vermont Service Center has become jaded over the years and is now like fine-tooth combing everything. And local offices may not understand domestic violence. So I don't really know why people are seeing it go better with IJs, but it seems like also maybe they're just more used to granting waivers and inadmissibility than.
So Tess is saying that the cases were quite straightforward and the IJ was relying on the applications and no questions were asked. That's great. Ashley is saying that fee waivers are easier before the IJ. I would imagine that that's especially true now that it's become so much more difficult to get fee waivers from the Vermont Service Center.
Oh, right. And she says they're not questioning the underlying relief, which well, so if it's true that your local office is doing that, you need to let us know because that violates their own memos and headquarters will have a chat with them. But you're right. We're having to re-educate the local offices on what the proper approach to VAWA adjustments is.
Yeah. Tess is also saying that DHS only asks whether there are any criminal convictions or gang involvement. Ashley says it's quicker. It certainly can be quicker. It depends a little bit on the judge's calendar, but it can be quite a bit faster.
Yeah, and I think, Bart, what you're saying is kind of what I was saying, is that they're much more influenced by all the positive equities they see. And I think they kind of get the underlying purpose of the law. But this, again, is where you might want to be talking about how this is part of this larger social project Congress started in VAWA to help survivors, blah, blah, blah. And then you can build these positive equities and they will want to adjust.
Yeah. So that's great. Thank you guys so much for sharing your experiences. And hopefully this is reassuring for people who have not done an adjustment in immigration court before, that it can oftentimes be actually more straightforward and easier than an adjustment before USCIS. It's probably a little bit more scary for your client in some situations, but it's potentially and actually an easier path to adjustment. And then for some data collection purposes, so in those cases where you were adjusting before the immigration court, why were proceedings not terminated so that the client could adjust before USCIS? So it sounds like for some of you, and if you could share your responses in the chat box again, that would be great. It sounds like for some of you, adjustments in court are actually much easier and potentially faster. So maybe that's why.
And I like that fee waiver argument, given the problems we're seeing with fee waivers too.
Yeah. So one person is saying that proceedings weren't terminated because the client had criminal convictions. So yeah, you may find OCC less willing to agree to terminate. You may find the IJ less willing to do so if your client did have criminal convictions, because the OCC considers this kind of termination to be an exercise of prosecutorial discretion. Tess is saying that she's done it that way because it was easier and faster, and the IJ was much more amenable to granting the fee waiver. Yeah, so there are tons of really great reasons to adjust in court, and then obviously there are going to be some times when you would like to adjust before USCIS and you're not able to get the proceedings terminated.
And I think, Amy, this goes back to one of your earlier suggestions, was just check with the other people in your area who do VAWAs in court and at the local office. They'll have good intelligence on which seems to work better and which IJs and which officers are more sympathetic.
Yeah. All right, so Gail, I believe you are up, because next we have VAWA cancellation.
Okay, so I'm dusting off the part of my brain that used to do training on VAWA cancellation, because we haven't really had to do a lot of it for the past decade at least, but we did do a lot of work on this in the past. So I'm going to be sharing with you some of the best practices and tips we learned over the years from it. Okay, and Lynn is mentioning that if OCC isn't agreeing to termination, the IJ will do the adjustment in proceedings rather than, that makes sense. Okay, all right, so as you know, VAWA cancellation is a form of non-LPR cancellation, and it's only available in proceedings. It appears to be covered by the CAP. I do want to go back and reread EOIR and the legislative history that we got put together for all those fixes I was mentioning, because I thought we got that exempted from the CAP, but I'll have to double check that. But right, so the biggest, frankly, other than proving up your case, the biggest barrier we're hearing from people who are doing these cases is that they've hit the 4,000 limit. So people are in limbo of some sort while they're waiting to actually get their VAWA cancellations. It's approved, but they haven't actually got it yet. And you do get lawful permanent status. And the best that we could do to deal with derivatives, and I think we got this added later on, like maybe 2005, was that they shall parole in the derivatives from abroad. I'd love to hear if any of you have actually succeeded in doing that, because as far as I know, they were just confused back then about how that could happen and who had jurisdiction to do it and all that stuff. So if you've been able to do that, let me know. And if you need to do it, let's chat again and we can pull up all the old arguments from a long time ago about what that would be. Okay, next slide, please. So this is a really great chart on the differences and similarities between VAWA cancellation and the self-petition. So the relationship to the abuser, as you all know, is one of the crucial things. What cancellation doesn't have is the elder abuse category that we got added to the statute in 2005 for self-petitioning. What it does have is essentially none of those 2-year deadlines for the ending of the relationship. So it doesn't require current relationship as long, this is completely statutory construction, by the way. Just the language of the statute, the way it's written, you don't have those links, plus there's nothing about the 2 years. So there may be, I mean, in the past, we've not actually suggested people get into proceedings because they are in one of these categories that isn't covered by the self-petition, but now you may find that there are people that you triaged for self-petitioning and decided they didn't qualify and maybe went for a U visa instead. They may still have a VAWA cancellation option. Joint residence requirement is not required for cancellation. Just a footnote on this, if you're getting VAWAs rejected for that, they're applying the wrong standard. We're going to litigate this, and we're actually involved right now in litigating and doing an amicus brief on the way they're interpreting joint residence for self-petitioning. It's just wrong. They're like reading the old regs or something and not the statute, because we got the statute fixed a couple times on the joint residence requirement. Continuous physical presence, that's something you need for cancellation, right? Generally, we did retain the 3 years that applied for the old suspension, so it's not either 7 or 10 under as it is for cancellation. And the notice to appear doesn't stop that accrual. So to the degree that like you're sitting with continuances or your merits hearing isn't for a long time, you may actually be able to accrue the time you need for a VAWA cancellation during that period. Good moral character is the same. There's also the same exception as you have for VAWA self-petitionings, and I actually think there's an interesting way to use that for this next question, which is inadmissibility, deportability. You know, that isn't per se an issue with cancellation, but the way that Congress stuck it in there for VAWAs is they have this little 4 in the general eligibility requirement that appears to create bars to VAWA cancellation based on these grounds. This is where, however, people have been making creative arguments that it's pointless to have this good moral character exception if you can't show the waivability plus connection to domestic violence at all, because the same ground that's a 101F bar is also a 212A 2 bar, for instance. That would be the most likely one. So if you feel like that little 4, which is what this middle cancellation list is a bar for a VAWA cancellation, talk to us and we'll figure out if, well, first of all, try to dig up those old arguments and figure out how you could proffer that to your judges. The other thing we actually used to see is that nobody read the statute, so they didn't realize that was a bar. And so you'd get it and you just argue, oh, it's good moral character, blah, blah, blah. And they never actually read that part of the statute. VAWA extreme hardship. So I doubt there are a lot of you that were around during the time when that extreme hardship used to be a requirement for self-petitioning. I think we got that taken out in 2000. But so the good thing was that we worked with the government, INS at the time, on a special set of factors for extreme hardship that were tailored to domestic violence, because the Anderson factors really mostly aren't. You know, they assume that you are not isolated and aren't under economic control and all that stuff. So we'll get into what those are, but because those had been developed in the INS context, EOIR agreed that they shouldn't be applying a separate set of factors to VAWA cases. So you'll find those factors now in the EOIR regs for VAWA extreme hardship. Next slide, please. And you're going to read the questions. I can't do that at the same time as talk. Okay, Amy? Okay, so here they are in the regs. And the way that I summarize this is basically think about a juxtaposition of all the stuff going on here, all the things that your client and his or her family need here that are availing themselves of, why we need them here, like our systems, versus what would happen to them in the home country. And the way they broke it down in the factors is it's the nature and extent of physical or psychological consequences. That's fairly straightforward. And then what flows from that is, what are they getting here? And people would emphasize the kids. Like the kids were in a violent home. Kids in violent homes, as you know, often need a lot of help and have a lot of mental health problems, and they may be getting support from teachers, counselors, some peer group. So you see, it's not the typical Anderson thing where you might just be talking about they don't speak English and, you know, I mean, they don't speak the home country language and they're acclimated to our society. They actually need and or are already using services here and support that they can't get in the home country. And the same for the survivor herself. Then that also goes on to what's going to happen if they get back sent home. Is the family, are their friends, is the society as a whole going to harm them psychologically or physically because they've, you know, either brought their community into disrespect because they challenged male authority, because they have a child that is multinational. This is very similar to some of the, if you've done any asylum work, to some of the work you may have done on country conditions, really focusing on what would happen to them if they go back. And the other services are like, if they need shelter, if they need counseling here, you need to show that it's unavailable in the home country, or there's like one shelter in the main city, and the reality is that most people can't get access to it, that kind of thing. And that, again, I think with CJIRS, you could find a lot of that already developed for the DV asylum context. And then this is, again, the relationship to DV asylum. You want to go back and show, look, especially if the abuser's from the home country, or if the abuser's a citizen who travels a lot to the home country, because that may be how they met, would they be protected back in the home country? Even if they have laws that allegedly protect them, do they in fact protect them? And that's related to the traveling back to the home country. So a case you might want to read that's really a terrific decision in the Ninth Circuit, and we did a lot of work on, is the Hernandez case. And you can find both the amicus brief and the decision by the Ninth Circuit there. And that was a case where the abuser essentially stalked her, but he was still back in the home country, and the government, or he went back, and the government argued that she shouldn't qualify because he was back in the home country. But we were able to show it was a pattern of abuse and that he was still stalking her, like through phone and email. So there's a lot of wiggle room here with VAWA extreme hardship. And you'll probably already have developed a lot of this in the self-petition context. Okay, are there any questions from this, or shall we move on? Next slide.
Yeah, go ahead.
Okay. So as Amy said, you always have to deal with discretion, right? We have the good moral character. I mean, they're more used to doing this, I think, in a kind of straightforward, like not we can do anything we want kind of discretion approach, which is what we've seen with the Vermont Service Center. I think they are a little more aware that there are limits on discretion. The remarriage is a question, but I feel like I'm sure I've seen an unpublished decision. I'm trying to dig it up, where the court has found that remarrying by itself doesn't vitiate the VAWA cancellation. And I can probably find, I mean, we can certainly help you with the arguments on that. Again, a lot of that statutory construction. But as you know, with VAWA self-petitions, if you remarry before the self-petition is approved, you vitiated your self-petition.
I mean, they've
yes.
agreed that, I mean, I think it's very clear that remarriage for VAWA cancellation is not going to be a statutory bar. It's a question of whether it's a negative discretionary factor.
Yeah, and so a lot of this is going to go back again, and you're all probably sick of me saying this, but the history and purpose of the law, right? Is that the reason this is so broad is because we are trying to hold perpetrators accountable and help survivors, and we don't want our system to be basically a weapon against them. So to the degree they can, there's wiggle room in the statute, they should be trying to help these women and men and children get status despite being abused in our country. So that the remarriage, if it doesn't, like, especially if it doesn't offer them another form of relief, I would say the argument is, especially if she still needs services, especially if she's still helping the civil or criminal justice system hold the prior perpetrator accountable, that should not be a reason to deny her immigration status, right? She should be rewarded for availing herself of the system, especially if this is an otherwise situation which, if the abuser had done what he should have done and filed for her way back when, she would have status by now. That's, I think, a very strong argument with a lot of IGs. That's a very elemental, basic form of power and control. And that's actually the reason Congress created the statute, is that they saw abusers holding the immigration system, their control of it, over their victims. And so the IJs need to be on our side in ensuring that abusers can't keep doing that. To the degree that one of the reasons that we got the good moral exception in the statute is that we could show that many survivors are charged and convicted of crimes, often at the behest of the abuser, sometimes because the police show up and don't speak the language and she fought back, and so she may end up with a DV conviction. The typical, or economic control, they have to shoplift because they have no money, that kind of thing. So that's why you'll see that also a lot of flexibility on the connection between criminal convictions and good moral character. And I think you can make those arguments also in the waiver context for adjustment, that, you know, I would even point, for instance, I would argue that the reason Congress created that 212H waiver for crimes of moral turpitude, for instance, that's just being a VAWA self-petitioner, is because they understand that survivors often get enmeshed in our criminal system and don't have what they need to get the kind of result that would not have immigration consequences. So feel free to work with us. We've written up the history and purpose of this stuff so many times we can parrot it in our sleep, and you can literally cut and paste a lot of it from things we've already written. Was there anything else on this, Amy, you wanted me to address, or should we move on?
I don't think so.
Okay, next slide, please, Maria. Is this back to you, Amy, presenting relief?
Back to me. I got a little distracted answering questions, so I'm finding.
Oh, okay.
Okay.
Do you want me to take over, or do you want to just answer some out loud?
No, I think we're okay. It was just a couple of questions about VAWA cancellation eligibility, with the issue around eligibility when the applicant was not married to the abuser, and the cancellation is a little bit more generous than self-petition when it comes to this, but it's also not wide open. So if the cancellation applicant was not married to the abuser, you would still either have to show that they had a child in common who was abused by the abuser, or that the marriage was, that there was an intended marriage, but that it was void because of the bigamy of the abuser. So.
Yeah, and actually I've seen cases with our first one. It's kind of like a generic common law assumption if you have a child in common that's abused. The other, if you have that situation, the other unpublished case to look at that's on our website is the board agreeing that children witnessing abuse is a form of extreme cruelty in itself. So that's a very useful case to use in conjunction with a, you know, a mom who isn't married to the abuser, but the child was living in the house with them. Between those two, you should be able to make a good VAWA cancellation argument.
Yeah, absolutely. I think you know, it's important to think outside the box a little bit when it comes to showing abuse or battery of extreme cruelty to the child, because you do need that. It's based on the abuse to the child. Okay, so next up, we're going to talk about how you actually would present these applications for relief. What kind of evidence would you be showing? So first up, we've got another poll. And this is actually our last poll of the session today. So just a quick one here. How much experience do you have in filing for VAWA adjustments in removal or VAWA cancellation? And your options are never done either, 1 to 5 cases, 5 to 10 cases, and too many to count. And Gail, we've got a question on that case, that published case we have on our website where the applicant wasn't married to the abuser, but there was a child in common. So while I'm doing this, would you mind pulling that up and putting the link into the chat box?
Oh,
that one.
Okay. I did send out to everybody that I said both of those cases are on our website. So if it's okay, maybe we could just add them to the Dropbox later, because I was pulling up a whole bunch of cases earlier. I'm not sure which one's which right there.
Sure. Okay. And whoever asked that question, if we forget to send it out, just shoot us an email. We'll send it to you.
Jessica, let us know, Jessica, if you don't get it.
All right. All right. So I'm going to go ahead and close this poll. So a lot of you guys have not done VAWA AOS in removal or VAWA cancellation, and then we've got some of you guys with some experience and some with a decent amount of experience. So this is not surprising. I mean, I think one of the issues we have these days is that for a long time, people weren't doing a lot of VAWA AOS in removal, right? They were doing it in front of USCIS. And then also, in many cases, VAWA cancellation was just not necessary because people were getting their VAWA sub-petitions and their U visas and other forms of relief granted by USCIS without being put into removal proceedings. And then also, I think the backlogs in immigration court have at least delayed a lot of merits hearings and people's ability to get a lot of experience in this kind of case. So we'll be asking those of you who have done these kinds of cases to share your experiences in providing evidence to prove up your client. For those of you who haven't done it, you can also participate and let us know, what kinds of evidence do you think would be appropriate? Do you have any creative ideas on how you would prove your client's eligibility for these forms of relief? All right, next slide, please. Okay. So we're going to be spending the bulk of this time talking about VAWA cancellation because that's a more unfamiliar form of relief for most people, but just briefly going over the VAWA AOS procedures in court. Obviously, you'd be filing the 485 and the I-601, the same forms that you'd be filing before USCIS. I think this goes without saying. I hope everybody's doing this. But it's really important to review form instructions very, very carefully. There are very detailed instructions that do change periodically. So even if you've done tons of 45s and 601s, it's always a good idea to look at the instructions every time you're doing it in case something's changed. And then also, I would hope that everybody's doing this as well, but ask your client every question that's on the form because your client has to sign these applications. Your client is swearing under penalty of perjury that they have read and understood every single question on this form. And then, of course, there are some BIA cases on your client's accountability for the information that they are submitting on their applications. The other thing is that your client needs to know what evidence is being submitted as well. So reviewing the evidentiary packet with them, even if it includes NGO reports on the availability of social services in your client's home country. I don't necessarily think that your client needs to read every single word of it, but your client does need to understand what evidence is being submitted on his or her behalf. And then in addition to the forms and the evidence, you're also potentially looking at an I-212 if your client is inadmissible under 212A9A for having that prior order of removal and needing that advance permission to reapply for admission. Okay, next slide, please. And Gail, you are back up.
Okay, so you got the forms and the fees, and it sounds like maybe you might want to do a fee waiver, and it's easier here. Remember that the evidentiary standard here, as opposed to the burden, is any credible evidence. And I think I'm going to come back to this later, but don't assume that that means you can just throw anything at the wall. Maybe with EOIR it's easier, but I think they've gotten to the point in the administrative consideration that they want to know why you can't get the best evidence, and that the failure to show them why you can't get, best being primary evidence, implicates the credibility of the evidence that you are supplying. So to bolster the credibility of whatever evidence you're supplying on qualifying relationship, better extreme cruelty, good moral character, all of this stuff, explain how you try to get what they might consider the best evidence, and that this is the best evidence you can get, and then why it's credible. So the normal, it's like self-petitioning, qualifying relationship, battery, extreme cruelty, good moral character. In addition to what you would do for self-petitioning, you have to show the 3 years continuous presence, extreme hardship. What does no bars mean? Oh, the little I, yeah. I actually would not address that up front. I would wait for one of them to say something about it. As I mentioned, that you may be able to get into the 240 proceedings without them noticing that there might be a bar, and then argue your problems in the context of good moral character and the exceptions and waivability. Okay, next slide, please. Okay, so one of the things I am generally suggesting, and this is what we used to do a few trainings on how to do cases and proceedings, and would bring an immigration judge with us, and they liked the argument back then that a self-petition essentially answers all of the questions of eligibility related to those issues, and that therefore the only hearing you have to have for the VAWA cancellation is on the elements that aren't answered in the self-petition. So if you have good evidence in your self-petition, whether it was approved or not yet, even if you're going for VAWA cancellation of the status of the abuser, I would use that, because otherwise you're going to have to go back and do all kinds of contortions you have to do to show the relationship when you don't have that information yourself. And it would be interesting to hear from you guys, if you start doing this, to what degree can you make the arguments that, the government should be able to look in their files and find it like we can with CIS? I think you're probably going to hit a hard no on that in court. Next slide, please. So again, this is very similar to what you do for self-petitions. It is any credible evidence. Again, you're going to have to explain why you can't get the best evidence, and then why the evidence you have supplied answers it. And if you have an approved self-petition, the other thing, this is similar to self-petitions, I think, where if there's some old I-130 or something filed by the abuser, that you should be able to ask the IJ to make the government get it, or to at least look in the file and find it and see if that supports your assertion that they are married, legitimately they're married, and the status of the abuser. Okay, next slide, please. So if any of you have done any other kind of continuous physical presence proof, you're pretty familiar with this. I think it may vary. I'd be curious to hear what you're hearing from IJs, what they require. Like, do they require something just from once a year? And what kind of documents are they looking for? Do you require like a job receipt for every week? What's the time period, within the 3 years that they want a showing from? And what is the best evidence that you can supply? A lot of these people have been living underground essentially, so they're not going to have a lot of government documents probably that would be helpful. So again, you're going to have to show that what you're giving them is credible, and you may want corroborating declarations, for instance, from whoever is supplying this kind of evidence. Okay, and we already covered the NTA. Yes, next slide, please. Better extreme cruelty. So you're going to have to educate most of your judges on domestic violence. And beyond that, you're going to have to educate them that extreme cruelty means any form of power and control that, especially for your client, subjectively, is a form of power and control. EOIR has not been trained on this in years. Last training I did for them was a decade ago, I believe. And I don't think they get any training nowadays, even much written material on domestic violence. And it is clear, however, and I believe that Hernandez case talks about this, that extreme cruelty is not tagged to any definition anywhere else, that its intent is to cover all possible forms of power and control, because these are people who essentially should have status by now, but for their abusers. So all this stuff in the first thing is primary evidence, right? Police reports, protective orders, all that stuff. Again, if you don't have them, because often there's in a client's story, whether it's going to be a declaration or testimony or both, they're going to talk about some interactions with these systems, and you can bet both the IJ and the OCC are going to say, well, why didn't you say anything about domestic violence? So to the degree that you can head that off at the pass with an explanation in the declaration, I've seen a few cases where someone brought in a DV counselor as their expert to explain why survivors wouldn't be explaining this. You could also do that with social science studies and reports that show that. But essentially what you're showing is that this is why the best evidence standard doesn't apply. The primary evidence standard doesn't apply to these cases, and Congress understood it because they don't, first of all, have control of most of the documents because of the way abusers behave, and they're afraid of accessing the system because of the abusers, and so you're not going to have a lot of systems documents. CPS is Child Protective Services. That's going to be particularly helpful probably for child claimants, but may also help for, if you're, to some degree, I think that if a child is being abused, they're often the parent is being abused as well. And witnesses to abuse, you could do declaration. This is, if you've done any other kind of case and proceedings, some of this is going to look familiar. Just remember that the standard isn't primary, it's any credible evidence. So you can use experts that are not people with lots of letters after their names. Experts on domestic violence are people who know domestic violence and done a lot of work with domestic violence survivors and can explain the experience that your client had to the judge, and often explain the behavior of the abuser to the judge. Because now that you've done a lot of these cases, a lot of this stuff is like, really? That person actually did that? That just sounds crazy. Can't believe someone would do it. Or that you apply your own lens, and you should expect immigration judges and OCC to apply their own lens. Well, like if this has happened to me, I would never do that. You got to head that stuff off at the pass. And so sometimes having a third person explain that this is extremely typical behavior, both from the survivor and the abuser, helps kind of vitiate that applying their own lens problem that we often see with immigration judges and OCC. And again, if you have the self-petition, I think one of the arguments you really want to make with IJs and OCC, if you have an approved self-petition in hand, is we don't want to re-traumatize the survivors. It's going to be extremely traumatic for them to talk about the abuse again. They've already done it in the self-petition, and part of the agency that's actually trained on domestic violence has agreed that this is a form of battery cruelty. So both for efficiency, Your Honor, in your courtroom, and to make this less traumatic for everybody involved, let's just focus on the continued presence, the VAWA extreme hardship, and any discretion issues or inadmissibility issues if you're talking about adjustment that we need to get into. Next slide, please. So same good moral character. There is that exception if you can get past a little 4 eligibility bar and get into the 101F bars. There's that exception that if it's waivable and connected to domestic violence, that overcomes the good moral character generally. And I think EOIR is a little tighter on this whole looking behind the 3 years thing. Vermont just kind of thinks it can look at anything, anytime. I think EOIR is not quite so, liberal or crazy in their interpretation of discretion. So yes, so the one problem here is the AGFELs. On the 101F, you'll see both AGFELs and crimes of moral turpitude listed. Some creative arguments have been that even though AGFELs aren't waivable, if it's also a crime of moral turpitude, that is waivable, and therefore, since it's the same act, they should waive it. I think part of your posture is to focus on the things that are waivable and argue about those and hope they don't notice the other ones, like aggravated felonies. But if they don't, then your plan B is, well, Your Honor, it's the same acts under the crime of moral turpitude, which is waivable in connected domestic violence, as the aggravated felony. So let's assume she's shown good moral character. Again, and for those of you who don't work with us already, this is exactly what we spend a lot of time with you on, is these kind of difficult arguments and creative ways around these problems and barriers. Pete, you will have heard me say, I don't believe that you should ever say no, that we will find a way to yes. I mean, we're still struggling with that now, but we want to work with you on that. So let us know, especially ahead of time, if you've got these problematic cases, and we'll try to figure out some arguments that you can present to an immigration judge with a straight face and meet the laugh test. Next slide, please. Okay, so these are these factors. I think we've kind of covered a lot of this in what I've said so far. The kinds of evidence that we've seen were very helpful in the past, and all of this was obviously the client's own testimony to the degree that they've never presented it before. It's going to be preparing for that's going to be very hard and completely essential. For those of you who've done, like my experience doing asylum in the 80s was, they would just break your client down as quickly as possible and try to show discrepancies by forcing them to come up with dates and like, so when did that happen? And force them to pick a date. And then they'd say, oh, well, that's not what it said in your declaration. So this is, again, why if you can get an approved self-petition, it'd be really helpful, and just bypass all of this trauma and attacks on your clients in proceedings. Because it's if you aren't already doing this with your clients, it's really important to use their way of thinking about time. So if their way of thinking about time is that the first hit happened like the day of my son's birthday, or a week after the spring rains, or whatever, use that time frame and stick to it. Don't allow the government to force your client to use frameworks that don't make sense to them, because that's just heading them into a credibility morass that it's much harder to overcome. I already talked about the importance of DV counselor testimony or declarations. Hopefully you're already working with them on these cases, and they're going to be vital to really getting out the story and helping your client present the story in a way that makes sense. And also they can corroborate it. If you can get primary evidence, that's great. I mean, I do think there's a question about it raises questions. I don't think it's necessarily should, but it does raise questions when your client doesn't see a counselor until it's time to present evidence in court, you know? And I guess we would say, you know, if you're really providing holistic services to a client who suffered DV, they should be seeing a counselor now. There's a lot of other stuff they need to deal with besides their immigration status. So hopefully by the time you're actually presenting the case in court, they have a relationship with someone who actually can corroborate a lot of what they said. The need for access to the system, you know, anybody who's in a family, I would say that's ongoing. Most obvious thing is that they're helping the criminal system, but that's not going to be true with a lot of VAWAs because they don't have to, and that's, you know, maybe they won't for a lot of legitimate reasons, like they don't want their abuser deported, who's providing support for the child, or sending a lot of money back to the hometown, all that stuff. But what hopefully is happening or needs to happen is a clarification of who has custody, because you, right now, for instance, given with all these raids coming up, your clients need that clarified. The worst thing could happen to their kids is they end up in the abuser's custody because they've been deported. So that's a real ongoing need for the civil system here that you should emphasize. Harm, again, we talked about, look at what the DV asylum says. What do they actually know? Is he still sending emails to her? Is he stalking her on Facebook? Now that we've got all these other wonderful ways that people can stalk and psychologically harm you, use all of that. Services here, again, this is where it's better that there's an established relationship. You're not just suddenly deciding she needs to go see a counselor and get support, that this has already been happening before you're actually going into court. And again, with kids especially, I would look at schools and teams and, you know, coaches. It does, the people who can provide helpful evidence for kids in particular aren't necessarily going to be, again, people with things behind their names. Are going to be people who have worked with a child and really can see the impact of the child of living in a domestic violence home. Laws and social practices that you can find on the DV asylum, that's going to be very similar to that. And similarly with the last one, it's going to be a combination of that and any facts you have on the abuser's ability to travel back and forth between the US and the home country, or if they're from the home country, the likelihood that they are there and their family's there and their community's there, that's going to harm your client. So next slide, please.
Gail, before we move on, going back to evidentiary issues, we've got a question. How do you deal with an IJ who insists on exact dates?
Well, I would, and I imagine if this is from Judy, what she already is doing is you object on the record, right, Judy? You say, Your Honor, we'll try to do it, but this is not how she thinks, and you're imposing a framework on someone that's inherently going to cause credibility issues, and I just want to get that on the record right now, that this is the way that she thinks about it, this is the way that she'd like to present it, and that this is being forced on her by the immigration judge and OCC. And Judy, if you have other ideas, share it. It's just, you know, I know, especially for people who are, well, I actually don't know. First, it's been frustrating to me over the years when I was working at the National Immigration Project to see attorneys who didn't want to like piss off the IJ. It's like, but what's zealously representing your client? And I understand if you're doing a huge caseload, not wanting to piss off the IJs, but I think we're living in a time right now where that should not be your concern. What should be your concern is creating a record so that on appeal, even if it's not at the board, but at a federal court, you can win, which means that when they're forcing you to do things that you don't think you should have to do, you have to say, I want this on the record, that I'm objecting to this, and this is why I'm objecting. Because you may not win that in immigration court, but you'll at least have it on the record for the board and for a federal court review. So Judy, if you have other thoughts on that, share them in the questions or the chat, and we'll put them back with you. Should I move on while she does that?
We've got one more question that's related. So if you have requested the IJ to focus on the non-abuse issues and accept the allegations in the I-360 as written, and the trial attorney insists on asking client detailed questions about the abuse on the stand, on what basis can one object?
Well, you're saying the IJ has accepted the self-petition into the record? I would just object that the OCC appears to be attempting to traumatize my client, right? Is the IJ going to allow the OCC to do this over the IC's acceptance of the self-petition into the record? And I mean, I know that a lot of IJs are doing that, kind of just bending over backwards to do whatever OCC wants. So again, I would object. and then I do what you can. This is, however, goes back to the preparing the client thing, because yes, you can never tell what's going to happen in court. I stopped practicing in court because they were making me cry because they were tearing down my clients in front of me, and it was really, you could object all you want, but they were in tears. And it was clearly their job to try to pick apart and undermine the clients as much as possible. I think you should just go into court assuming that's going to happen, and have your clients prepared for it, and object on the record. I don't know. I'm curious, those of you who do cases in court, what do you think about saying I object and I'm instructing my client not to reply? Wonder what, because I think to some degree nowadays we need to act more like criminal defenders. Because I think the system is really targeting our people now, and we should behave as if that's what's happening. But again, you're gonna have to feel it out as you go. The worst, as you know, as I keep saying, the problem with doing it is what they're trying to do is find credibility holes in what your client's saying, and so they're going to keep asking questions. They're going to keep badgering her until she says something that is different than what she said in her declaration or in her self-petition, and then use it with the IJ to argue that she's lying about everything.
I think for both of these questions, it's partly an issue. So with the question about an IJ insisting on exact dates, I think that what Gail said about, maybe you won't win in front of this IJ and you have to take it up and appeal to the BIA, depending on your IJ, that's entirely possible. But I think that the best thing that you can do for your client in that position is provide a plausible explanation and a credible explanation for why your client doesn't remember the exact date. And that maybe having your client explain why she can't remember it. It could also involve, secondary sources and expert testimony about what it means to, how human memory functions and how traumatic memories are formed and things like that, that will help support your appeals case if it comes to that. If you have an IJ who is just determined to find your client incredible no matter what you do, then that's your IJ, but you plan for an appeal. And generally speaking, I think the BIA and the circuit courts have been open to other explanations. I don't think I've ever seen a case where they said that somebody was incredible because they could not remember an exact date. And then when you're
a couple additional resources on that is that I think a lot of people have had to do that in the asylum context, and so you can find it there. And then I just found, and hopefully it's on our website or it'll be on it soon, an amicus brief we did, I think many, many years ago to the board on credibility, that kind of outlined all these things that Amy's talking about, all the reasons that assumptions about how survivors testify are wrong. And so the social science sites are probably old, but they'll give you a lead for where to go for more of that.
Yeah. And then for the question about the objections, I think we're looking at the same objections that would apply in any court, right? So if the TA is badgering your client, then that gives you a basis for objection. So, in immigration court, I think it's sometimes we forget about the objection rules and evidentiary rules because they're so loosey-goosey, which is oftentimes in our favor. But to the extent that you can use these rules and objections in your client's favor, then do so. I know there's an organization, what is it, VITA or something? They partner with Clinic and they do a great trial advocacy course for immigration court a couple
times.
NITA?
Yeah, we did a training with NITA, the National Institute of Trial Attorney Trainings, and it was fascinating actually to get trained on how to make all these objections like you would do if you're operating in a real courtroom. And I think Amy's right. I think it'll freak out the judges in the OCC for you to be making actual real objections. That this is actually a case that you're heading towards federal court, which is unfortunately where I think you need to at least think these cases are going to go. Then it will look good in federal court that you made those kinds of objections on the record that they understand. So I think it's easy enough to review those. One thing we could do, Amy, is try to dig up some of those old materials that from NITA on those kinds of procedural objections and content objections and share them with folks.
Sure, you'll probably know where they are more than I do, but we can certainly try to dig those up.
Oh, here's Judy gives a really good example on the dates thing. So maybe give the judge an example of applying for the state bar where you're asked for 15 years of addresses and employment. I love it. Like make it real for the judge. I'm sure the judge didn't remember all of that without references and a ton of papers in front of her. Maybe a little cheeky, and maybe there's a way you can do it that's kind of like, Your Honor, it's just a human thing. And it's like, for example, an example we can understand. That's a great idea, Judy. Thank you. Did we answered Sarah's question, Amy?
Yeah.
Okay, great. Okay, I think that Amy is actually in the process of drafting an advisory on working with your clients on declarations. So it's kind of what we've already talked about. We do, I think, still have some old training materials on taking your clients' declarations and preparing for testimony. If any of you haven't had training on preparing for testimony, we'd be happy to share that with you. It's worth a whole hour in itself, to be honest. But as we have here, you want to describe the general pattern of abuse. It has to be in their own words. Amy, you had some practice pointers on this that I think you might want to share. Like the first, worst, and most recent instances. Why is that a good idea? You still there, Amy? Did I lose you?
Yeah. It's helpful for your client's memory. For a lot of clients, especially ones who have a long history of abuse, it's very, very difficult to remember chronologies even, forget about specific dates. But sometimes the first and the worst and the most recent instances really stand out for people. And so it can be nice to structure their testimony and the chronology of their testimony around things that they do remember very, very clearly, as trying to get them to remember things that they don't remember quite as clearly. And that goes with the point of using timeframes that make sense to your client, right? It's oftentimes that the first, worst, and most recent instances are timeframes that make sense to your client.
And building on what you're saying, I also this is where I would not apply your own lens on what matters with domestic violence, because one of the things that became clear when we were working with INS early on is that it's helpful for the declarations to describe the very idiosyncratic experience that they have. That it's not you cannot get online and read what DV is, and that will not describe what your client is experiencing. What they actually experience is very peculiar to their own lives and often can be bizarre. And it may be helpful to actually have them, and that may be the situation. Like it may be something like, he made me leave my suitcase next to the door because he knew that was what happened to my dad in the home country. The KGB and took him away, and that was what they made him do. That was an example that the original head of Vermont Service Center gave to us about how making it idiosyncratic and then explaining how that's a form of power and control actually is very compelling because it distinguishes your client from everybody else. So think about that. Okay, so we move on. One thing we have seen, there was a period where the board and some of the judges didn't understand that battery and extreme cruelty didn't mean physical abuse. So you may need to do a little background explaining to them. That's why I got into it a little bit early on. Don't let them focus only on physical abuse, because that's absolutely not the intent of Congress on this. Next slide. Okay. I already went through the experts issue and the ways that I think they can be helpful. The reason I mentioned them providing facts and explanations, that there was actually a case where we did an amicus brief. This was very early on. And the argument was solely based on the domestic violence counselor's testimony, because the person herself was unable to articulate very well what was going on. And the judge then dismissed everything and wouldn't pay attention, but it was in the record. And so we were able to use the record to say to the board, the judge should have paid attention to the counselor because the counselor explained what was going on, and that was satisfactory. And I think the board remanded that case. If you have money or your clients have money, you might want to think about paying for some of these things, but you really shouldn't. I mean, this is one of the reasons we've been pushing the experts don't have to be, shrinks approach, is that I know that that's the standard in other areas, and you may be having to educate your judges, but when we've trained with IJs and you proffered is like, what does expertise mean? Why does going to to getting a master's, making more of an expert on your client's experience of domestic violence than the counselor that's actually been working with them for 4 years. I think there's a way to frame it that it makes it clear that the expertise you need for these cases is actually facts and analysis of the facts and education about what DV is and how it works, not so much these, you know, she's got PTSD and mental health problems kind of thing. Okay, next slide, please. Okay, so the big problem is the cap. I'm going to do some research to see if we did get anything in EOIR, although people keep telling me we didn't, but I'm just going to double check. And then the derivatives, as I mentioned, let us know if you're winning these cases and struggling to figure out how to get the kids paroled in under D5. I'd be very curious to hear if any of you have actually succeeded in doing that. Back in the day, we couldn't figure out how to do it. Next slide, unless Jenny we want to share any of the things that Jenny shared before we move on.
Yeah, Jenny has some great suggestions on the question of memory. I think this is going back to Judy's question about the IJ who's insisting on exact dates in testimony. And Jenny suggests making the argument that the effects of PTSD are avoidance and trauma as defined by damage to the hippocampus. This is coming from an in-house psychologist, and that this damage, this brain damage, can significantly affect memory.
Good.
And that's absolutely true. There's tons and tons of scholarly research on the effect of trauma and PTSD and things like that to the brain, and specifically to people's abilities to form memories and to recall events, all of which can be helpful when you're trying to explain to your judge why your client can't remember a specific date, or when you're trying to set up your record for appeal.
So I'm just going to throw this out there because it just occurred to me, but I think a lot of what happens with the psychological abuse is really kind of a form of brainwashing. I wonder how that relates to PSD and to memory and that kind of thing. Just throwing that out there. Next slide, please. There we are, questions, yay, I'm done.
We have a few minutes left. If anybody has questions, you can put them into the questions box, and then we'll try to respond. If they are super case specific, we may ask you to submit it as a TA instead of addressing it to the whole group. But if you have any more general questions, then feel free to ask. In the meantime, as we're waiting for questions to come in, you can reach either Gail or myself at the emails on the screen in front of you. Also, if you are an assistant member or an OVW grantee or an NIP-NLG member, then you can submit technical assistance questions to us on any issues that you're having on your survivor-based cases. If you're new to our TA program, we can take up to 10 days to respond, but we do get back to you. This can be useful if you're having some issues in figuring out strategy for a case, or having trouble with research or understanding a concept, or also sometimes if you have cases that are stuck with the agencies and you need help getting them unstuck. And then if anybody's not already on our listservs, we've got some very active listservs, specifically the VAWA experts. So you can send us an email to be added to the group. Okay.
So Astrid's wondering about the U webinar. I assume what you mean is the one that's more on procedures, which is really what mainly you can do with these. That's going to be in July. I don't know if we have the date yet. While she looks for that, I also, for those of you who don't know already, Sejal Zota, formerly of the National Immigration Project, is now working for us as a consultant on litigation campaigns and already working on discretion in the U context, NTAs, fee waivers. There isn't a lot happening on VAWA except VAWA reinstatement, and that we just got knocked down in the Ninth Circuit, but without explanation. So Bob Powell thinks we can keep working on that. If you have litigation issues or things that you think need to be litigated, let us know, because now's the time. We're putting together the overarching plan and building out who needs to be involved, bringing in firms. We're also putting together a litigation mentoring system for those of you who've never litigated, whether you're an NGO or a private practice. I want to pair with an experienced litigator. We're going to set that up so that you can work in pairs and learn how to do it together and how to get admitted to your federal court. Because unfortunately, in addition to removal defense, we're going to have to be going to federal court to make sure the government's doing what they should be doing in this area.
And then with the procedures and removal proceedings webinar, right now we're holding it on July 24th. That's a Wednesday from 2 to 4. The registration link is not live yet on our website, and I think the date, it's possible the date will change. So we'll be sending out lots of announcements on our listservs once we get things finalized for that.
Our plan, as I understand it, Amy, is we will be doing a webinar every month. Right?
Mm-hmm.
Pretty much? Yeah.
Yeah.
Okay, good. So, and we'd love to hear from you, other topics you want us to cover.
I'm not seeing other questions coming in, so I'm going to put in our evaluation, the link to our evaluation. So we have a webinar evaluation form. If you guys are so kind as to fill it out, we really appreciate your feedback. And we do review your responses and try to incorporate them as we develop additional webinars. So I have just put it into the chat box. Hopefully it's showing up for folks. And that is our webinar evaluation form, and it is anonymous. So you can feel free to be as honest as you like and let us know what's working and what's not.
And if you haven't gotten one of our fabulous t-shirts yet, I encourage you to do so.
Okay, so I am not seeing any other questions, so I think we can go ahead and close out. As one final note for anybody who missed the announcement about the CLE credit, if you are in Texas and submitted, or are licensed in Texas and submitted your bar information when you registered, then that your attendance information will be submitted automatically to the Texas State Bar. If you didn't submit that information when you registered, or if you're licensed in another state and you would like a certificate of attendance that you can submit on your own, then you can email us. You can email me or Maria, and I'm going to put Maria's email here. It's not letting me. Okay. Manager. Okay, so I'm putting Maria's email into the chat box. If you are licensed in another state and would like a certificate of attendance, please email either Maria or myself, and we'll make sure to get you your certificate of attendance that you can submit for CLE credit. All right, and I think that will wrap us up for today. Thank you, everybody.
Thanks, everyone. Keep in touch.
We hope to see you again in July for part 2.